So one of the questions that has come up in the public debate is whether or not the advance notice by HHS after the initial blowback and intense debate in some ways could potentially solve the claims that this represents somehow cooperation with evil. And now some have accepted that. Melissa Rogers on the panel this morning suggested that that does solve the problem for some organizations. But I wonder about the strong claim that some have made that this in fact is, a shell game, is sort of really still having religious organizations contracting for these services.
Who's this to?
Kathy?
Well, I mean, whatever the law does on this matter, that is one thing. I think Catholics have to have a conversation in Catholic terms about what's at stake here. I don't see how, I've been very impressed with the Obama administration rules on a number of fronts. The proposed rules. One is, and I think this point, Bob, you made, there is no essentialist definition of religion. Law doesn't deal in essentialist definition. It's functionalist definitions for a particular purpose, not for a particular purpose. So the idea that the government is labeling you as religious or not religious by virtue of how it's framing an exemption from a particular law doesn't strike me as the right understanding of how the law works in the American context. The revised, notice of rulemaking says, we are not saying to you Catholic universities and Catholic hospitals that you're not religious or that you're any less religious than these other institutions. What we're trying to do is come up with an exemption that balances a range of rights. The way I see what's at stake here, the most frustrating thing, for me in this whole discussion is I think we Catholics have lost a lot in the way we've talked about this. We have been the people who have said, rights have to be understood in the context of communities. They can't be framed as trumps. And yet we are putting forth the notion of religious liberty as a trump without analyzing how it fits into other contexts and other communities. We are the people who say the golden rule, is the first material principle of the natural law. Do unto others as you would have them do unto you. How are we looking at the claim from the other side? I haven't seen a lot of Catholic doctrine taken seriously, the claim on the other side. And I do think there are religious liberty claims, as Father Langen pointed out, on the other side, on the part of employees. One of the things we could ask is, what are the basic benefit packages? What kinds of claims of healthcare should you have available to you no matter where you work? What are the basic human rights, basic rights in the context of healthcare that travel with you everywhere? If we frame this discussion that way, and not just in terms of religious liberty, we're going to come up with, I think, a broader discussion, as Lisa would point out. And I haven't seen much of that. So I'm afraid that in pushing our claims of religious liberty, which I'm not saying are not legitimate or don't have some aspects of it, but the way we're doing it, we're sacrificing so much of how we as a tradition bring forward and model ethical discussion. And that's what wearies me most of all about all of this. That wasn't an exact answer to your question, but sorry, that was my own statement. Yeah.
Patrick, does that address and in some ways cure some of the concerns you have about the conversation? You wrote a very compelling piece early on in this conversation in which you pointed out that the reaction by the bishops and others on the right, the bishops and persons on the right, as well as the bishops, had in some ways adopted the very privatistic language of religious liberty and individual autonomy that you found troubling on the HHS rule itself.
Well, no, and actually, I very much agree with the concluding remarks of my colleague in pointing to the way in which this debate has been framed in highly individualistic terms, the invocation of the rights that we are accorded, of conscience. All of these terms, of course, don't need to be construed or understood as individualistic, and I think the Catholic tradition, as I think everyone here has acknowledged, except for Robert, begins with a deep understanding of the relationship of these concepts, which have been largely adopted in the liberal parlance in an individualistic mode, how they are embedded in a deeper context that considers community, the common good, and the natural law. But at the same time, I note that Kathleen began her remarks by suggesting that this is how the law works in the American context, that the law doesn't give you another way to talk about this. And this was really my complaint. And so my complaint is probably just fundamentally systemic, and I may not be all that helpful to you budding lawyers out there, that the way in which these debates are framed within the American liberal context necessarily force you into that language. And what I was trying to point out in that piece was that in some ways this becomes a self-defeating argument, even for those who want to stand for the place and position of the church, that they're forced into a language that they don't initially accept. And so my strong pushback in my comments is that obviously in part making an argument for what we might consider to be forms of corporate rights, institutional and associational rights, which seems to me is embedded in our Constitution, but which is often neglected or downplayed in preference to individual rights. And this is something that I think has been a great witness of the Catholic tradition within the American tradition, which it was not initially included in the founding, but which it, I think, has offered a great succor and assistance. And finally, I guess in regard to the specific question on the panel, while I think, and I understand that the way, again, looking at the framing argument, that the way that this argument is framed is that these are institutions just like other institutions that go by the name of university and hospital and social services, that are employers and have employees. I think it is fundamentally necessary to understand that these institutions were not founded on the same grounds as their secular peers and counterparts. They were founded as parts of the church, as part of the church's ministry. And I think we fundamentally misunderstand these institutions as fundamentally indistinguishable from their secular peers if we don't acknowledge that that was the reason for their existence and continues to be the reason for their existence. So, yes, it's very difficult, as Robert points out, and we do have to engage in some casuistry in sort of determining and weighing claims about what is and is not religious. But it seems to me that one of the things in a liberal society that comes first is a great deference to that claim, and certainly given the long historical presence of these institutions and of this church in this country, that claim ought to be given great deference and more than I see being given right now.